What you missed on the previous episode of Plugged In with Seeff
And
Properties.
then in terms of documentation for conveyancing, what's normally required?
So the starting point is to understand what are conveyancing transactions. My advice would be, if you don't have an experienced agent assisting you and you're doing a private deal, then rope in the attorney or conveyancer as soon as possible.
The marital status. So what it means if somebody's married in community or out of community. I was going to talk about the challenges with conveyancing, but I think I'll just leave that till the end and then go straight into the married in and out of community.
So the simplest way to understand it, if you're marrying someone rich, marry in community of property. If you're marrying someone poor, marry out of community. The reason is, the day when you do marry in community of property, what it basically means is, you're basically saying whatever is yours, whatever was yours before that date, goes into one pot, and everything in that pot, both the good and the bad. When I say the bad, means if your spouse that you marry comes in with liabilities. When you marry in community of property, 50% of his or her liabilities also become yours. So basically everything goes into this one pot, and there's a 50% equal ownership transfer that happens automatically with respect to those assets. Out of community means whatever is yours, whatever is his is his. But some in modern, or let me not say modern times, but the most convenient structure that I found, I know that it's not about, the segment is not about advising on that, but the most common structure that people are entering into is marriages out of community, but with accrual. So that means that whatever I owned before getting married to you remains mine. But whatever I get after marriage, it becomes ours.
I just want to also talk a little bit more about, say, now when you're married in community of property. So if a couple is married in community of property, I understand that situation where you say everything that they own individually has now been brought into a pot and they own collectively. So, but if one party wants to go into, say they want to buy a house, the other party has to consent and they have to be involved in that process. So I couldn't buy a house on my own without my husband knowing, for example.
Okay. So when you acquire property, where the consent is required is if you're going to negatively obligate the marriage. So for example, let's say if you, Dabilo, you purchasing a property and you married in community of property and you've got the cash. You can go out and buy the property and we can transfer the property into your name. We don't require your spousal consent. In terms of the conveyancing documents that are required. Now, if you're going to get a loan from the bank, the bank will require your spousal consent. If you're going to register a mortgage bond, we will require the spousal consent. So if you see that if you're acquiring property into the marriage, usually, in fact, spousal consents are not required as a document, as part of the documents that are required at the deeds office. But where you selling, if you're selling property and you're married in community of property, or even if your marriage, if you can't clearly prove whether you are in or out, then the spousal consent is required.
And so also being married in community of property means, so if, say now I do get the loan and my spouse has consented and I default, for whatever reason I can't pay, the bank would come back to me and say, you owe us this amount, and I say, well, I can't pay. Do they also then go to my husband and say, give us the balance?
So remember, generally when it comes to real estate, the banks have got a mortgage bond over your property. So what they do is they first exercise their security rights in terms of recovering from the property. So, the process is called foreclosure. They'll first foreclose on the property. If they don't recover all their, whatever amounts are owing to them, after the sale of the property, then they can go after both spouses' assets.
Right.
Because remember, the law doesn't look at, if, for example, if your wife or your husband is driving a car and you married in community of property to him, they can attach that asset because what you own effectively 50% of that car.
Of that car.
Yeah.
Right. Okay. Because I just wanted the listeners to understand that the depth and what it actually means.
Yeah.
Because we've seen even now. I mean, you would think that being married or getting into marriage in community is an old-fashioned thing, but there are still young people who are getting married in community of property, and they do come across these snags here and there where things happen, the marriage doesn't go so well after a few years, and then they find themselves in these situations.
Yeah, I would advise your viewers that they should consult. There's this thing of if you don't marry in community of property, you don't love me.
Yes.
Type of you don't love me and this marriage is not going to last. But in fact, you'd find that if one spouse is the risk taker, and one spouse is for example, doing all the business, making the deals, and making the money, things can also go wrong. Yeah. And that's when it will come back and bite them and say, you know what, we should have married out of community. Yeah. So at least our family assets are safe. Yeah. They don't fall part of your husband's estate. Because, you generally, a lot of businessmen take high risks. So, it's good to separate that. So, yeah, my advice is they should consult. They should when it comes to this issue here, they should take the emotions out of it and consult and see what works best for them.
Exactly. And if you married in community of property, can you down the line apply to come out of community of property, so to speak?
Okay. So I just want to put a disclaimer. I'm not an expert when it comes to that, but from my knowledge, you can apply to court.
Okay.
And there's a process. I believe there is a process under I don't know if it's the Married Persons Properties Act or the Matrimonial Causes Act. I'm not too sure. But there is a process where you can apply to court and then you can change your marital regime. But I think you have to advertise it and I'm not too sure.
The process, Back to conveyancing, the cost involved.
Yeah.
So take us through that,
people always say that the costs are heavy, and obviously because we are on the receiving end, like you guys as estate agents, you always say that your fees are not enough. There's always a difference of opinion, but in terms of conveyancing fees, from my experience, and I'm not saying this because I'm a practicing conveyancer in Botswana. Conveyancing fees in Botswana are very competitive. If you look at the market that we're in, and also if you look at South Africa, Zimbabwe, Namibia, we've got the fees are very competitive. How the fees are based, it's based on a tariff.
Right.
So you've got the Deeds Registry Act, and out of the Act comes the Deeds Registry regulations. Right. And the regulations got a prescribed tariff. So there shouldn't be any, when it comes to conveyancing fees, in terms of the actual registration fees, there shouldn't be any conveyancer that charges higher or lower.
Right.
What actually happens is the difference in fees comes in terms of the hourly charges of the attorney. Right. So a quick example is if you come to me and you say, Akheel, I need you to assist me with the sale. So I'll ask, okay, what are my instructions? Are my instructions only to do the registration? Mm-hmm. In that case, I'll only charge you in terms of the tariff. But if you say that, no, I want you to hold my hand and structure the sale and assist me with the bank, then I have an hourly rate that I charge, and I will charge you based on my hourly rate. Okay. There is, like, for example, if it's a standard sale agreement, we'll tell the client it's a standard sale, it doesn't require much time. So those fees are negotiable. So your hourly rates, whatever is not tariff-based is negotiable. And it's based on the attorney's own charge-out rate.
Okay. Let's touch a bit on wills, Akheel. We're at that stage now where parents and people are growing, especially with this pandemic now, what's happening. How important is it to have a will, especially over movable property?
Yeah. So look, every circumstance is different, but the general rule is that, you know, if you do organize and put your life in order, one of the biggest things you can do for your family is to have a will. You know, number one, it helps, especially when there's multiple beneficiaries. So, you know, it helps with the avoidance of disputes. It also helps in terms of the process of transferring the assets after you pass away. So you'd find that in Botswana, there's, you know, in Botswana, if you have a will and you have a will and you pass on, that means you've died testate. Right. So what happens is that your will spell out your last wishes in terms of what happens to your assets, right. And those assets will be transferred in terms of your wishes. Right. If you don't have a will, then you then told that, I mean, you basically are now considered to have died interstate, right. And your assets will then be devolved. It goes into a pot where all your beneficiaries will benefit. Mm-hmm. And the general rule is that it's like customary law. The general rule is that each beneficiary will benefit from your assets equally, despite your wishes of maybe saying my eldest should have this house in this place. You know. So if you don't specifically state your wishes, then what happens is you're leaving it to your beneficiaries to decide how your estate is going to be shared and distributed. Okay. Yeah.
Okay. And do they have to when you're writing a will? Can you do it at any point in your life?
Yes, you can do it at any point, even the day before, as long as your mental faculties are good. You can even do it on your deathbed if you're in hospital. It's your last wishes. So remember, you can only have one will. So that is the reason why if you see a proper will that has been drafted, it will always say, "This is my last will and testament. I revoke all other previous wills or testamentary documents." So that means that you don't want conflicting documents after you pass on. So it's worth mentioning, one of the most common mistakes I see from a lot of our clients when we're discussing wills is that they'll say, "Okay, we'll do a will in America for our assets in America. We'll do a will in Botswana for our assets in Botswana. We'll do a will in South Africa." So they want to do wills for in every that may cause problems depending on the laws of the other jurisdictions. In Botswana, for example, if you bring two conflicting wills, it's now you've got a conflict. Right. It will determine on many different factors on how it's going to get resolved. Right. So it's always best to have one will, and that will can cater for all your assets all over the world, because that will can be used in any country in the world. You just need to get that will recognized.